tonight's workshop is about the study by vzbv, and now I'm struggling to say that in English, the German, the consumer protection organizations. And we're going to take a look at the study conducted by Dr. Christina Irion from the University of Amsterdam on AI regulation in the European Union and trade law. And I'm very curious about the findings of the study. I already had the extreme honor to read it in preparation of this event, and I can tell you it is as interesting as it can get on this topic. And so very much warm welcome to Dr. Irion. Thank you very much for being with us, Doctor. To Mr. Klaus Müller, who is the Executive Director of the Federation of German Consumer Organization. Thank you very much as well. The chair of the IMCO committee, Anna Cavazzini. Thank you very much for being here with us, Anna. And warm welcome to Ben Lange, the chair of the Intertrade committee tonight as well. That is a great honor that we have two chairs of two EP committees as well. And welcome to Christoph Kiener from the European Commission from the DG Trade. So we have a very high profile panel tonight, and I'm very happy to hear the contributions on the topic of the EU AI regulation and trade law. It's something that so far has not been so broadly discussed, but it has a huge potential. And before I'm going to give the floor to Klaus Müller, I'm going to share some thoughts on these topics for tonight as well. And as I think many of you are aware, we're talking about doing some pioneer work in the EU, creating a legislative framework for artificial intelligence. About a year ago, the Commission published their white book on artificial intelligence. And since then, the European Parliament has worked on a number of initiative reports to find a position on several aspects of AI regulation, such as liability regime, AI and international law, judicial system, ethical aspects. And I'm quite sure we're going to touch on a few of those things tonight as well, because we're all, of course, trying to find the best legislative approach. And I think two of the questions that have always been pressing is how many risk categories of AI do we need, and which of the existing legislation has to be updated and to what extent. No matter the topic, that was always the underlying points. And I think while there quite a lot of disagreement remaining in the different institutions or in the political groups in the parliament, I think it's consensus that we need independent audits, for example, for AI systems, especially when we're talking about high risk and AI uses, because especially focus should be giving to consumer protection. And therefore, it's especially interesting to talk about tonight's study, because for the first time, there's going to be light shed on the question whether the EU is actually limiting its future digital policy through current negotiations of e-commerce rules on the WTO level. So I really can't wait for Dr. Irion to share her findings with us tonight. So and hear political input from Ms. Cavazzini and Mr. Lange as well, and of course to hear from the Commission, because no matter if we're talking about AI, if we're talking product liability, if we're talking as well the big two legislation this year with the Digital Service Act or Digital Market Act coming up, I think it's important that we handle this on a European level to avoid fragmentation of the single market and to ensure highest consumer protection as possible. And therefore, of course, it's juicy to understand, is maybe the Council and the Commission undermining those efforts in their current WTO negotiations? So I hope I could excite you a bit for tonight's topic. I'm very excited for it, and I'm giving the floor to Mr. Klaus Müller, the Executive Director of the vzbv, and then followed by Isabel Buske, who is going to moderate tonight. Mr. Müller, the floor is yours.
Well, thank you very much, dear participants, dear Svenja Hahn. Thanks for hosting this joint workshop, and thank you very much, esteemed members of the European Parliament and colleagues from the European Commission for joining our discussion this evening. Also, a warm welcome to the representative of member states and all the stakeholders that join us tonight. vzbv, which is the pronunciation we use in English, has been following the political discussion around AI, its implementations for consumers and regulatory options since quite a while. We have been members of the Data Ethics Commission of the German government, and we are actively contributing to the current debate on AI regulation at the European level. But before talking about regulation, let's have a look what German consumers think of AI. In September last year, the European consumer organization BEUC did a multi-country survey on the perceptions of AI. The result? German consumers are generally in favor of AI, but at the same time, they are concerned about safety of their personal data. They are afraid of manipulation from companies and generally do not trust AI applications. It's evident that as long as there is no, at least minimum, transparency and accountability of AI technologies, consumers will not fully trust AI. And this trust must be built through legislation. AI applications can bring many benefits to consumers, let me stress that. But at the same time, they can influence their behavior through the personalization of offers and can transform entire markets. To give you an idea of negative consequences of AI for consumers, let me cite one example from the study Christina Arion will present in a second. The case is fictitious, but not unrealistic. Please think of a booking platform that could exclude consumers based on the analysis of personal traits. The new software of a US accommodation booking platform automatically searches social media and news to obtain information about their users. The available information is analyzed for behavioral and personality traits. The software then classifies users for traits of narcissism, psychopathy, drugs, and alcohol abuse, and more. In our scenario, let's call him Bob, is a frequent user of the platform. He works maybe for a Belgian wine retailer, for which he regularly travels European wine regions. Bob is also a fan of Greek mythology, and he frequently posts on social media about his passion of wine and mythology. Lately, Bob finds it somewhat more cumbersome to be offered attractive rentals via the booking platform, as he's not aware. What Bob doesn't know is that the platform algorithm has assigned a higher risk score to him based on traits in 3 categories: psychopathy, negative language on social media, and substance abuse. Looking at this example underlines that we need to open the black box of algorithm decision-making. What does this mean in practice? Very few people are able to look at the source code of algorithms and understand them. What we need is a meaningful modular approach to transparency and accountability. This should entail different levels of disclosure, depending on the risk that specific applications pose to citizens and to consumers. This is what the German Data Ethics Commission proposed to the German government after careful deliberations among different stakeholders. Such a precautionary approach would consist of a toolbox of ex-ante enforcement of rules, public and private enforcement, and of course, relevant technical and financial powers to regulatory authorities. When talking about AI, we talk about a technology whose full impact, benefits, and dangers still remain to be seen. It's important to leave enough policy space to future developments. Therefore, we commissioned the study Christina is about to present to ensure that trade agreements do not hinder the regulation of algorithms in the interests of consumers. We are still at the dawn of a fundamental transformation of the economy and society through artificial intelligence. The European Union must ensure that trade agreements cannot undermine consumer protection today and not in the future. So thank you very much for your kind attention, and I'm also looking forward to the speeches to come. Thanks.
Yes, thank you, Klaus. Good evening, ladies and gentlemen. My name is vzbv. I'm the head of the Brussels office for the Federation of German Consumer Organizations, and I have the pleasure to guide you through this short seminar tonight. So now is probably the part that everyone has been looking forward to, is Dr. Christina Irian's presentation of her findings. Christina Irian is assistant professor at the Institute for Information Law at the University of Amsterdam. And she has been working since many years on the intersection of trade law and digital. On top of her own research, she provided expertise not only to consumer organizations like us, but also to the European Parliament, the Dutch government, and the OECD. So Christina, thank you very much for joining us tonight, and the floor is yours.
Good evening, and thank you for having me. I'm super pleased to present this study to you, which was a hard work during Corona lockdown. And now it's accomplished, and I'm happy that it sees the day of the light or of the evening. Greetings from Amsterdam. I'm going to fire up the presentation now, and it should be nicely visible. So, I have the pleasure to introduce you to the study AI Regulation in the European Union and Trade Law. I have been commissioned by the German Federation of German Consumer Organizations, better known as vzbv. I'm working at the Institute for Information Law here at the University of Amsterdam, and I'm specialized in the governance of transnational technologies. The aim of the study is to explore how a high level of consumer protection can be achieved in the context of AI applications that are supplied to consumers from outside the EU. And this is our itinerary for this short presentation. We will look at what consumer AI technology is there, the approach of the study. We will look at the WTO electronic commerce negotiations very briefly, and then zoom in on the EU proposal on the source code of software and what implications this proposal has on EU regulation of AI systems more broadly, but also the implications for EU consumer rights and accountable AI. That is then followed by the conclusions. Consumer AI technology is already very present in the life of average consumers in the European Union, and they bring, of course, many benefits for consumers, but also they can influence consumer behavior and the choices they make. On a large scale, AI can profoundly transform consumer markets by, for example, enabling fully personalized consumer transaction on a population-wide scale, if you want. AI-powered consumer services rapidly diffuse across the global digital ecosystem, and that is because AI is very easily tradable across borders. The reason is that AI technology is fairly fluid, and its predictive outcomes can be applied at the distance. Individuals who are at the receiving end of AI systems must be reassured that these technologies operate in a way that respects their fundamental and consumer rights. My study compares the EU approach to the governance of AI in light of EU consumer rights with the EU proposal in the World Trade Organization's negotiations on electronic commerce. This has not been done in that form before. The EU proposal backs a new clause on source code of software. This has been a cause for concern for experts and rights advocates, as such a clause, if it is not carefully conditioned, can prevent future EU regulation of AI that may be harmful to consumers. This study ascertains whether algorithms used in AI technology qualify as source code of software and how such a clause affects current and future EU policy that aims to ensure accountable AI. Now, international trade law is made in different venues, but especially under the roof of the World Trade Organization. But it can also come into existence in the form of preferential trade agreements to which the EU is a party. The General Agreement on Trade and Services already covers cross-border trade and digital services, also if these digital services incorporate AI into their software architecture. That means that a WTO members measure that restricts cross-border trade, cross-border digital trade could thus be assessed for its conformity with the GATS. The conclusion is that the GATS already governs AI, and that doesn't come as a surprise for many trade lawyers, but it should come as a surprise for the general public and even some policymakers, because the GATS is from 1994. The negotiations have taken place before that, but of course it has been flexibly adopted to live into the future and also accommodate digital trade more broadly. Currently, under the roof of the WTO, also with the participation of the EU, there are new negotiations for a new agreement on electronic commerce. While not all negotiation positions are public, the EU proposal from early 2019 is publicly available. Last summer, 3 countries, Australia, Japan, and Singapore, have consolidated all these proposals into a single document that shows over which parties and issues parties converge or diverge. However, I have not seen this document, it is classified. So I'm basing my analysis on the EU proposal on source code that is available. And this proposal dates from April 2019, it's not that fresh anymore. So let us zoom in on the proposal for a new clause to protect source code of software. You have it on the screen. This proposal aims to prohibit that members to such an international trade agreement require the transfer of or access to source code of software owned by a natural or judicial person of another member. This source code clause already exists in EU trade policy. For example, it is already part of the EU-Japan and the EU-Mexico agreement that both date from 2019. Also, in the EU-UK Trade and Cooperation Agreement, which covers the relationship after the UK's withdrawal as a member state from the EU, a source code proposal is included. The inclusion of such a source code protection into trade rules on electronic commerce is frequently justified as a way to preclude forced technology transfer by parties to such an agreement. These are measures that force foreign companies to divulge proprietary source code as a condition for market entry or in the context of foreign direct investments. Such measures can be particularly interfering with business secrets in high technology sectors, for example. However, due to its novelty, there's currently no experience with a new trade law discipline protecting software source code. And there's insufficient analysis of its scope, its application, and effects in practice, but also in how far a violation of such a discipline can be justified. So what is source code of software? The exact meaning of the term source code of software is very decisive to understand the scope of such a clause. If there's no definition provided in the agreement, then we have to fall back to the rules of treaty interpretation that are set out in the Vienna Convention. They would guide how to interpret a clause in an agreement. In a first step, we have to establish the ordinary meaning of source code. Inside computing, source code means a program in a source language. The ordinary meaning of source code is not static, but dynamically connected to the state of the art and the evolution of source languages in computing. In a second step, it is established whether the ordinary meaning of source code would also cover computer or machine learning algorithms. The answer is that an algorithm is commonly expressed in source code using a source language. That can be a hand-coded or text-based algorithm, but it can also be source code that is already using more modern source languages that are visual and self-learning. Summarizing, based on its ordinary meaning and interpretation of the term source code of software includes machine learning algorithms once they are expressed in source language. If, however, computer and machine learning algorithms are expressed in source code and would thus be protected subject matter under the new trade law clause on software source code, this has, of course, repercussions for AI regulation currently planned, but also in the future. Not only have we an issue with the protection of source code of software when it is concerning algorithms, but there is also the effect that the whole AI system is protected under this clause that also includes the application programming interfaces. These are important interfaces that provide the gateways to and from the algorithm, where the input data is given to the algorithm and the output is produced. As a consequence, a legislation that requires auditing of source code in the form of a white box audit, but also auditing of inputs and outputs of an AI system via these interfaces, this is called the black box method, violates the trade law clause on source code. This means that the EU's possibility to adopt rules that, for example, mandate external audits of AI systems will be confined to the policy space that is allowed under trade law. So what regulatory autonomy is left under trade law? A WTO member's autonomy to adopt a GATS inconsistent regulation is confined to the limits of the GATS general exceptions. Note, however, that justifying a trade restrictive measure pursuant to the general exceptions is not so straightforward and has to comply with several conditions, trade conforming conditions. This is especially true in areas of domestic policy where there are no international standards and that tackle new digital technologies, such as algorithmic accountability and external audits. Also, the risk and proportionality assessments that are performed in EU and member states' legal systems do not necessarily converge with those that are conducted under a WTO general exceptions test. So therefore, this can actually deviate. It is a limitation. In the study, several policy options are listed that would likely be found inconsistent with a source code discipline inside trade law. For example, the European Commission's white paper on AI proposes the introduction of prior conformity assessment of high-risk AI applications by certified testing centers. The Germany's Data Ethics Commission recommends always-on regulatory oversight of algorithmic systems with a high potential for harm through a live interface. Also, the brand new Digital Services Act proposal requires very large online platforms to enable vetted researchers to study systemic risks by accessing data via interfaces, APIs. Insofar as such a measure only targets AI technology's highest risk levels, they are more likely of being justified under the GATS general exceptions, which are geared towards minimizing trade restrictions. Other configurations, however, that require arrangements for interface audits at moderate risk levels of AI applications or prioritize general interest objectives over source code protection could risk falling short of a justification under the GATS general exceptions. And what does that mean for EU consumer rights? Consumers are among the first to experience mass personalization and algorithmic decision-making. A recurring theme is AI systems' characteristic opacity and intransparency, and the difficulty of proving that an AI system is faulty, biased, or unfair. Note also that interfaces of AI systems are bound to become important gateways for algorithmic transparency. Committing now to a trade law clause that would make it harder to engage with AI systems via these interfaces or mandate standardized interfaces in the interest of auditability would be counterproductive. The source code clause is too broad for domestic digital policies that need to build on interoperability, accountability, and verifiability of digital technologies. The findings of this study are derived from a complex chain of legal interpretations, which are not in plain sight. EU trade policy documents make no reference to artificial intelligence, only to electronic commerce. And no direct link has been made between the clause on software source code and algorithms. However, the source code clause has repercussions for EU policymaking in the field of accountable AI that are real and deserve a public discussion. Note, moreover, that public policy formulation today operates under conditions of uncertainty. We cannot foresee all possible risks that may arise from a particular or wholesale impact of AI and protected interests in the EU. Likewise, research into mechanisms that can hold AI systems accountable is still in its infancy. It is very important to provide space for the evolutionary development of transparency and accountability mechanisms that can be expected in the future. In light of this, the study recommends two options. The first one is that the European Commission should clarify the impact of the source code clause on digital policies of the Union, in particular consumer rights, and meanwhile give up on this trade law clause, since software source code already enjoys copyright and trade secret protection. Or second, that the European Commission should limit the trade law clause to the situation of forced technology transfers for dishonest commercial practices, or carve out measures on algorithmic accountability from the scope of this clause. All of this would be prudent and provide time to develop robust domestic policy as well as international standards on accountable AI. Thank you very much. That's all I brought for you.
Well, thank you very much, Christina, for this thorough presentation. Before we open up the floor, we will first hear comments now from the two major committees that have to deal with consumer-friendly AI and AI regulation in one way or another, and with trade policy on the other hand. First, I would like to give the floor to Anna Cavazzini, who is the chair of the IMCO committee in the European Parliament and member of the Green Group, for a reaction to the study's findings. You have 5 minutes, Anna, and after that we will be turning to Bernd Lange, the chair of the INTA committee in the European Parliament and member of the S&D Group, for his reaction to the findings. So Anna, first of all, the floor is yours.
Yeah, thank you, Isabel, and please give me a sign if I run over the time. First of all, thanks to Svenja and also to the vzbv for the invitation and for organizing this webinar, because I really think that international trade policy, that also trade negotiations, take the e-commerce negotiations, deserve more public debate, because we heard today it is very, very important what is being negotiated there, and especially I think on the digital side, on the e-commerce, there's very little public debate. So thank you so much for organizing this event today. Let me say one thing, because I also have an IMCO and an INTA head today. Like Svenja, I picked the nicest and most interesting committees. That I think what the study shows again in principle is how important international trade rules are, because they are in fact at the end superior to EU and national legislation. And that's why it is important that international trade rules are set in a correct way, and also of course scrutinized by the parliaments and by the citizens. So this is one thing that is very important to say. I think it is also very timely that we talk about the proposal today, because as you know, the IMCO committee is at the moment working on an own initiative report on AI, as well as, of course, the INTA committee, Bernd will talk about it later, is of course scrutinizing the e-commerce negotiations. So in both committees, we have some processes where the findings from today, of course, can play a role, and this is very important. I would say, in principle, we have to make sure that, trade policy rules don't restrict basically the right to regulate and the policy space. And this is also, I think, one of the main findings I read in the study. And I think this is really, really important. You mentioned it. We are working at the moment in the IMCO committee on so many digital files that are crucial. We really try to regulate the digital sphere. Not yet the AI legislation, because it's not out yet, as you know, but of course the DSA and the DMA, and I think the AI will be the third big digital file this term. So I think it is important that all our efforts the EU is doing, the Parliament is negotiating, and whatsoever is then not basically contradicted by international trade rules. I have to really admit that for me it was new to read about this source clause provision that the EU is negotiating. I have not heard of it before. What I read from the study, for me, it makes a lot of sense. The conclusions that were presented on the last slide to really make sure that while, of course, there is the necessity to whatever protect European businesses, I understand that, but that we have, on the other hand, a carve-out clause or whatever, a kind of a security that our upcoming EU legislation is basically in line with the international trade rules. This is very important. So I'm interested really to hear what the Commission is saying on that, but because I think it's really, really good proposal. Let me probably from a green perspective add 2-3 things in principle when it comes to the AI and also the e-commerce negotiations. I think we have to make sure that we also make the rules fit for the green transition also in the digital sphere. I think we have to make sure that we don't basically exploit the developing countries. As we all know, data and tech and so on is like raw material, and I think we have to, in these e-commerce negotiations, also include the perspective of the developing countries. Of course, for the Greens, data protection and privacy is high on the agenda, and then of course also open technology and interoperability. And I think especially this point on open technology refers again back to the AI and the source code, because of course we want to also democratically control of what is going on there. So these are my 5 cents to the debate. I think 5 minutes is quite short, but I'm happy to come in again in the debate. And thanks for the interesting study and shedding light on a problem I was not aware of before, I have to admit.
Thank you very much, Anna, and you were perfectly in time. So now it's my pleasure to hand over to Bernd Lange. Please, the floor is yours.
Thanks a lot, and thanks a lot for the invitation, and also thanks a lot for bringing this, let's say, problem on the table. And I'm also convinced that the consequences of AI is not properly discussed in public at the moment, specifically regarding the consumer protection issues. But let me react with 5 points on the study. We are discussing at the moment, my first point, we are discussing at the moment the due diligence obligations for companies to avoid violation of human rights and labor standards and so on. And of course, we need a monitoring system. And AI is a tool we can use. And of course, supply chains are international, and we need really international AI systems to have a proper monitoring system. So they are learning, and they can be quite neutral, and so on and so on. I will not explain this in length because I have only 5 minutes. To have it, we need, of course, international rules. And there I have a question mark to the study. Of course, if you have the aim to establish international rules, you limit your freedom. And it's not possible to have international law and on the other side, everything, the freedom, everything to do you want. So my consequence would be to ask for proper international regulation, which is necessary to regulate AI, then to go out of the system and try to make my own game. Second point, the e-commerce negotiations are quite a bridge-building system between developing countries and developed countries. And this is in the WTO quite new. And this is also interesting for developing countries, bringing them a better chance for having competition possibilities towards developed countries. And therefore, I'm really supporting the process, not in all details, in the process to establish proper rules. So my second point is indeed, let's discuss proper rules so that specifically developing countries have their chance. Third point, source code is really a sensitive issue and is indeed in the center of the discussion of the e-commerce negotiations. As you know, around about 90 countries are now on the negotiation table, and there are really two different views on source codes. We have the let's say USMCA and CPTPP countries led by the United States, and they made clear the definition that source codes are also integrated the algorithm. Specifically, the US considers as a really key that source codes protection provisions would cover self-learning algorithm, and this is covered. And the EU position is totally different at the moment. It's clear that we are not going in line with this, and we are not accepting explicit any inclusion of an algorithm. And I see no change in this position at the moment. And perhaps the Commission should make this very clear that this is the case. Of course, even some EU business are really in favor of integrate algorithm as well, because of the fear that this might be open the door for forced technology transfer. But this item should be dealt in a different piece of legislation or different rules in the rulebook of WTO, as we try to do it in some bilateral agreements as well. Fourth point, yes, consumer protection is also in some regard in this e-commerce negotiations, specifically on the hardware, on the standards, on the product safety. And we have to really extend it to the software as well, and specifically also regarding transparency requirements. So on the one hand of the coin, on the one side of the coin, the protection of the source code, no doubt about. But on the other side, we have to really create transparency. So the question, who is programming AI? It's an important question. Normally, it's the traditional white man, the specific thinking. And by the way, there are really interesting discussion on that in South Africa, for example. And fifth point, indeed, the discussion is not over. Huh? So you mentioned at the beginning there is this white paper from February, where some reflections of the commissions are in, and they, in line with the reflection on AI, there are some European legislations necessary. And of course, this will also sharpen the definition of source code. And as Anna said, yes, in the intercommittee, we are discussing just on Thursday the draft for our position to the e-commerce negotiations. So there is not a final European position on that. And so the discussion today is really timely, and of course we will reflect this and take your ideas on board. Thanks a lot.
Thank you very much, Bernd Lange, for those thoughts, indeed very timely. And now I'm very much looking forward to the reaction of the European Commission. Thank you very much for attending. And I know that Christoph Kiener and his unit, I think there are at least several people are attending. Thank you very much for making it in several numbers. So you're leading on services and digital trade. You're in charge of all things digital, actually, in the EU's trade policy. And you're part of the negotiating team for the WTO e-commerce negotiations. So Christoph, thank you very much for joining us tonight, and we're very curious to hear your first reaction. The floor is yours.
Thank you very much, Isabel. I hope you can hear me well. First thing I want to say is that indeed this invitation to speak about source code and artificial intelligence, WTO e-commerce, is very, very topical. It so happens that we were meant today, earlier in the afternoon, to initiate inter-service consultations or inter-service discussions within the European Commission on a first draft proposal by our colleagues from DG Connect on the issue of artificial intelligence. This whole process has, however, been delayed, I guess only by a few days. But it shows that we are precisely at a time where this kind of discussion can be particularly useful. So congratulations for doing this. Now, exactly as you introduced me, Isabel, I happen to work on the trade dimension of the digital economy. It goes without saying that I would not describe myself or portray myself as an expert in artificial intelligence. And that for all these things that the Commission is preparing, DG Trade, where I do work, relies a lot on our good and close cooperation with colleagues in DG Connect, who are the real masters of that file. And in particular, I'm looking at Klaus. You know, if we have to look into a black box, I certainly am not the person to do that. They would be the more appropriate persons to turn to. But today's discussion is about the trade dimension. And so the first thing I would want to do is, of course, to thank the German Association for Consumer Protection. I will not try the German acronym because despite my name, I happen not to be German. I thank you for commissioning this study. It's very good that Mrs. Irian did this. The only caveat I have, and if you allow me, the introduction to the discussion made by I think it was Svenja, who introduced today's discussion, asking the question of whether the Commission was undermining the possibility for the European Union to regulate about artificial intelligence. And here I think we need to be a little bit serious when we organize these things, because obviously the Commission's view is that we're not. And on the contrary, we go at very great length in order to ensure that we do exactly the opposite, that we preserve our room for maneuver, that we maintain the European Union's right to regulate in the context of our trade negotiations. Now, when it comes in particular to the issue of consumer protection, this is a pretty good example because myself, but my colleagues as well, are regularly meeting with colleagues working in the European Bureau for Consumer Protection. We, at least on our side, think that we have a very positive and constructive way of cooperating on consumer protection issues. And until now, at least my sense was that on the other side of the table, there was also an acknowledgement that this cooperation had been very good. And in particular, more specifically, that the provisions, the proposals put forward by the European Union in the context of the WTO negotiations on electronic commerce were extremely positive. At least this is what I had been hearing until now. Now, turning to the particular study there, I have to say that I fundamentally and very strongly disagree with the conclusions that are being brought. And I must say that I regret, certainly on a personal level, it would have been nice to meet Christina Irion again, but I certainly regret that there was no effort made by the authors of this study to approach the European Commission to at least hear our version of the story. For such an important and comprehensive study, I think it would have been good to at least give us the opportunity to express our views on this. Now, it is true, as Christina, as Mrs. Irion said earlier, that the GATS is technology neutral and that therefore it covers services regardless of the way of the technology that is used in order to supply services. So it is true that we do already, as European Union, have a number of international commitments that are legally binding on the EU, which we need to respect when we regulate, whether it is for consumer protection, artificial intelligence, the protection of personal data, and so on and so forth. Now, this being said, the issue of source code is not covered specifically in WTO law, which is why in ongoing negotiations, a number of WTO members, including the European Union, have put forward proposals to ensure that mandatory disclosure of source code would be prohibited. And that is an extremely important issue because for EU companies operating abroad, they happen to be confronted to real situations where you do have states, government authorities that do demand the disclosure of source codes, and that with the risk then that these technologies, this know-how be passed on to local, domestic, national competitors, national champions in an unfair manner. So it has become a standard feature of trade agreements, not only in the WTO, but in bilateral and regional trade negotiations, to include provisions on source code. And the EU does that already for quite a while. We have provisions on source code in force in our agreement with Japan. I think we're going to celebrate the second anniversary of the entry into force of our agreement with Japan in a few days. We just concluded negotiations with the United Kingdom, so that agreement is obviously a little bit more recent. But we also have provisions on source code, for example, in our agreement with Mexico. So this is not exactly a case where we are operating in a vacuum. All these agreements are, of course, public. They have been in force for a while, and they have been discussed quite extensively, including the WTO proposal that the European Union put on the table. This is one thing, perhaps just a short parenthesis, also in response to Mrs. Cavazzini's good remarks. Of course, we need more public debate on WTO negotiations on electronic commerce, just like we feel that we need more public debate on trade policy in general. And hopefully the upcoming trade policy review will be a good opportunity to do just that. But if you allow me more specifically on WTO e-commerce, beyond the fact, as Mr. Lange stressed earlier, that the INTA committee is following those negotiations very closely, there is a dedicated monitoring group that I attend regularly in order to report about the state of play of those negotiations. I report, of course, to member states as well, but in addition to that, I regularly attend a meeting of the civil society dialogues where the Commission is being questioned by civil society stakeholders, as should be the case in a democracy like ours, about the negotiations on e-commerce. Now, continuing with my remarks that I wanted to make about the study. Our interpretation, turning to the substance now, our interpretation of our text proposal is actually very different from the one that we have just heard. And I fear that this is where the misunderstanding lies. We are, and this was confirmed by Mr. Lange, we are firmly of the view that our own text proposal does not cover machine learning algorithms. And I can tell you, I was leading the negotiations on services and digital trade with the UK. This has also been the subject of lengthy discussion with our British friends and partners, who also wanted to have an addition to the language which the European Union supports, an addition which would have made it explicit that we would, in addition to source code, we would also protect algorithm, very much in the way that the Canadian proposal operates, and this is a text that is public, so it is covered by the study. Now, when it comes to the position of countries like the United States or Japan, their official formal proposal is not public in those negotiations, but obviously you can deduct a little bit what their position is likely to be in those talks if you look at the public documents around the USMCA agreement or the US-Japan agreement, which in both cases does cover algorithms specifically, in addition to covering source code. And let me stress that this addition of algorithms was done building on the experience gained in TPP negotiations, where you don't have this specific mention. So it was a way to correct what was perceived by those countries as a weakness of the TPP agreement by adding an explicit reference to algorithms to make sure these would be covered, because otherwise that was not considered to be the case. So there we have a disagreement about that, and I can tell you that because of this, and perhaps paradoxically for the conversation we're having here and the views of the authors, the European Union, I am often accused of being too shy on this issue in the trade negotiations that we do. And I have to use very much the arguments that I have heard you make earlier, that, you know, this is an emerging area for regulation, that the European Union is initiating a process of regulating artificial intelligence within the single market, that in the meantime, we'd rather follow a precautionary principle-based approach in order to keep all the policy space that we would need potentially. I mean, I have not even seen the first draft regulation from my colleagues in DG Connect on artificial intelligence, so I cannot tell you what the ideas are, but certainly what I have made sure in very close cooperation with those colleagues is to ensure that the European Union's proposal would not infringe on the possibility of the European Union to regulate. So I'm very surprised, because it's the first time ever that I'm confronted to this argument that the EU proposal would actually already have decided everything behind closed doors without any public discussion. And again, we are often accused rather of the opposite. Let me also stress that when I raise these questions, for example, as I did a few weeks ago with my British colleagues, they were all stressing that even if the European Union were to take commitments on those issues, including an explicit reference to algorithm, for example, in the provision on source code, there would be nothing that would prevent the EU from regulating artificial intelligence in any event, because you have exceptions in the WTO. In addition to the right to regulate in a non-discriminatory manner, you then have exceptions in trade law that allow you to regulate, and it goes without saying that the protection of consumers it would be a legitimate public policy objective that would fall under those exceptions. So in other words, my message is that we have belts and braces when it comes to the interplay between trade law and artificial intelligence. We do not have explicit commitments covering algorithms. We differ with the authors of the study on their interpretation of the coverage of our source code provision. And from that perspective, it would have been very interesting to have the possibility to have a discussion while you were writing your study. That would have been constructive, I think. But at the same time, even if there were to be a situation where some elements of artificial intelligence were indeed already covered by some trade commitments, we would have the possibility to regulate and to benefit from I'm sorry, I'm being called probably by my boss, but I'm trying to ignore that call. We would have the possibility to use the room for maneuver provided by the exceptions that exist in all trade agreements. And when it comes to the EU proposal in the WTO, and I will end with this because I've been too long, we are explicit about the fact that the provisions on source code is subject to all the exceptions under the general exception, the security exception, the prudential exceptions that we have in the WTO. So thanks for this opportunity to present the Commission's views on this, and I'll be happy together with the other speakers, I'm sure, to respond to any questions that you may have.
Thank you very much, Christophe. Indeed, I think you made very clear where the differences lie. And I can only say for vzbv, and I think I can also speak here for our European umbrella group, BEOC, that we do indeed appreciate the way you engage with civil society. So that is certainly not on the table for discussion here. I would now like to invite Christina, I'm sure you have taken many notes, to briefly react to the comments that we just heard, both from the European Parliament and from the European Commission. And for our audience afterwards, we're very happy to take questions from the audience. Please, we are almost 60 participants, I think, at the moment. So we would like to ask you to use the chat function rather than the raise hand. It's easier for us to follow. So instead of typing down the question, please just state your name and the organization or affiliation and who you would like to answer your question. So you can already prepare your questions while we have Christina giving a first reaction to what we just heard.
Thanks so much for all these fruitful comments and reflections, and for engaging with the study. That is lovely. I keep it brief because I want to also allow much of the audience to have a chance to ask questions. But I think I want to reaffirm 2 or 3 things that came out here. First of all, it is true that I actually come to a different conclusion when interpreting this term source code of software than what the Commission and Christophe Aquina has expressed. I actually say that it doesn't matter if you write explicitly algorithms inside this provision, but if you just use the interpretation of treaty rules, then you arrive there that yes, this is also source code of software. It doesn't matter if you write algorithm explicitly inside or not. Why that matters for us is a different reason, because once this has been concluded, the interpretation of this clause will be given to trade law fora, and they are not bound by the perceptions we are discussing this evening. They can form their own opinion, and since I said before, I think they would arrive that this is already part of the package of the deal, and therefore the deal is done. I also would like to highlight that we talk about source code of algorithms all the time in all other policy documents. I would be really surprised if suddenly it emerges that algorithms are not expressed in source code. I actually believe that this is a phantom discussion, and that this study will hopefully help to clarify that once and for all. However, I also think we should not overemphasize only this aspect of the study. The more actually important part is also that we would protect interfaces, application programming interfaces, that are very, very important to carry out the so-called white box testing method. White box testing is actually much more preserving for the business secrets of the owner of an AI system, because it will only query the inputs and the outputs and look why the algorithm treats individuals, consumers differently. And by protecting now also these interfaces as source code of software, and there we don't have this interpretation problem if an algorithm is inside or not. Interfaces are coded as software. Then we also make it much harder to introduce white box testing as a method to hold AI systems accountable. Then I also do totally not believe that that the European Commission and DG Trade is negotiating in bad faith. That is not my intention. What I think is that we have here actually quite some bycatch, I call it, yeah? There is a good intention. We want to protect European companies from this unwanted forced technology transfer practices by other countries. And by doing it this way, and the way how this source code proposal is currently framed, our bycatch is enormous. That means we are gonna actually submit the entire digital policy portfolio of the European Union to the trade law exceptions. That is not necessary. Already at this moment, of course, trade law covers cross-border digital trade to a certain extent. We heard that earlier from Christopher Kiener, and we don't need to now put more shackles on it. What is possible, however, is to find a more smart phrasing for this source code protection that would basically eliminate the forced technology transfer without at the same time also already embarking on possible new ways of AI governance. Okay, and yeah, with that, I would actually like to leave it, and thanks for everything.
Thank you very much, Christina. I'm sure that there will be more questions for you to answer.